Well, good morning, everybody. Welcome to today's webinar in the SeedFast series on the process and milestones of a financing round. Today, we're holding the third webinar in our series on financing rounds in English. And in this series, we present all the key elements and milestones of a financing round. In the first webinar in this series, we outlined the individual steps of a financing round. And then 2 weeks ago, we presented the various forms of a capital increase. When we are publishing all the slides and recordings of those webinars on the LinkedIn pages of Consento and of Lex Futura, and we will also make them available on the website of SeedFast. It is therefore worth following these pages and visiting them regularly. Today, we're focusing on the challenging topic of term sheets. Many of you may already have heard that investors would like to see and discuss a term sheet and that it also needs to be signed. But what exactly is it for and what is regulated in it? Is the content legally binding or is it simply an indication? And something I'm personally always struggling with myself is the question whether that content of a term sheet is carved into stone or if I can adapt it individually to each investor. I would like to welcome Alain Friedrich from the law firm Lex Futura. He will present the term sheet to us today and clarify those fundamental questions.
Thank you, Dominic. A warm welcome from my side as well. As Dominic mentioned, today's topic is the term sheet. And we start with the basics. What is a term sheet? A term sheet, sometimes also referred to as a letter of intent or a memorandum of understanding, is typically the first step in a financing round. It lays out the key investment terms that the parties intend to follow. It is usually negotiated between the founding team and the investors. And in practice, Dominic, here an answer to your question, the terms rarely change significantly later in the process. So the term sheet is a very valuable and important document. It helps identifying deal breakers early before time and money is spent negotiating the final agreements, which are much longer and which go into much more details. Once the term sheet is signed, the definitive agreements, such as the investment agreement and the shareholders agreement, are drafted based on the term sheet. And we will talk about these agreements later in the webinar series we are doing here. However, you are right, the term sheet is not binding. There are a few exceptions. For example, the confidentiality clause, the exclusivity clause, the governing clause, and the jurisdiction clause, they're usually binding, but not the others. However, again, the term sheet generally sets the tone for the agreements that come later. When we look at the timeline, you see that after you do the pre-term sheet discussions, so basically after you talk to your investors and try to convince them to invest into your startup, the term sheet is more or less the first legal document that you and the investors are going to sign. Sometimes you also sign an NDA, but that's quite rarely the case. So the term sheet is the first more or less legally binding document you sign. So what does a term sheet include content-wise? The content of a term sheet can be broken down into three main categories: economic terms, control terms, and other terms. Let's start with the economic terms. First, quite easy or quite simple, the investment amount. It defines how much the investor is going to invest into your company. It seems simple, but often you have to discuss whether the investment is made in one go or whether it's tranche-based or staged payment, whether it's contingent upon certain milestones later on, or whether he imposes or the investor imposes certain closing conditions. What you have to think about before you approach investors is whether you have a minimum investment amount. Do you accept investors that just invest 1,000 or do you have a minimum investment? That's quite important in that respect. And one other important aspect of a financing round, and already at the term sheet stage, is the cap table. You have to understand what happens to my shares or to my percentage in the company if the investor invests 1 million or 7 people invest 1 million, 2 million, 3 million. As you probably can imagine, this also depends on the valuation. That's the next point, the pre-money valuation. This determines how much the company is worth before the funds are injected. Obviously, it directly impacts your dilution and is therefore a central negotiation point. As a founder, you want to have a very high valuation, and as an investor, you want the lowest valuation possible. Here, a small tip. If you intend to implement the ESOP, an employee stock option plan, one of the points you have to discuss with the investor is whether the stock option plan is pre-money, so dilution of the additional shares that are issued based on the ESOP only dilute you as a founder, or it's post-money, which basically means that the ESOP is diluting both of you, the investors and the founders. Let's get to the ESOP. So a portion of the shares is usually reserved for current and future employees because it's quite rare that startups pay market salaries, so they need to have another incentive to incentivize employees. Usually when we talk about seed or pre-seed rounds, we see 5 to max 10, 15% ESOP. The term sheet should clarify this. Is the ESOP pre-money or post-money? And who bears the dilution? The details of the ESOP are usually not part of the term sheet. They're determined by the board of directors, and usually the shareholders agreement contains a passage which clarifies how much is the dilution or how large is the ESOP pool, but the details and the vesting conditions, stuff like this, is not part of the term sheet or the shareholders agreement. Then we get to the liquidation preference. Sophisticated investors, you could say everyone basically requires to have certain preferential rights, and the liquidation preference define the return the investors get before all other shareholders, before the founders. The market standard in Switzerland is 1x non-participating preference. Basically, the investor can decide whether they want their money back or participate based on their percentage in the company. At the moment, some deals also include participating preferences and sometimes even 2x or even 3x, non or participating. This also shows when it's difficult for companies to raise money, the terms are more favorable to the investors. And if the environment is good, then you basically end up with a 1x non-participating preference clause. Then anti-dilution. This is also a protection for the investor. It basically protects the investors from down round. Well, what is a down round? It's a financing round at a lower valuation than the one in which the investors invested in. If a down round happens, an anti-dilution clause ensures that the investors receive additional shares at nominal value to maintain or partially restore the value of their original investment. Here, there are quite sophisticated formulas. The thing you have to remember, for you, a weighted average anti-dilution is better than a full ratchet, which is extremely dilutive for the founders and very beneficial for investors. Then one of the main terms to discuss are the vesting clauses, the vesting for the founders. That basically means that the investor wants you as the founding team to be operationally active in the company for a certain period of time. And if you leave the company, you have to sell back the shares, usually at nominal value. So it basically incentivizes the founding team to stay with the company. What's standard in Switzerland? 4-year vesting with 1-year cliff. And then, very important, and that's something you should also discuss on the term sheet stage, is what is a good lever? Basically, in case of a good lever, you can keep certain shares, and what is a bad lever? Again, you have to pay attention to the details, because if a certain aspect is considered to be a bad lever event, and this happens, you have to return all shares at nominal value, something you probably want to avoid. These are basically the main economic terms. And then something else that is very important for investors are the control terms. They set out the facts or the resolutions in which the investors have a say. The key components are important resolutions or reserved matters. Investors often require a veto right or a consent right for certain matters. These are corporate decisions on a board level or on a level of the general meeting that could significantly impact their investment. So basically, the control terms are here to protect the investment of the investors. For example, the issuance of new shares, sometimes a change in the article of association, the sale of IP. Always, this is very important, the investors, they want to have a consent right or a veto right. On both levels, you always have a list of important matters in the annex of the term sheet at the board level. So all the matters that are determined by the board that are important, usually the representative of the investor has to consent. And at the shareholder level, it usually requires a qualified majority to consent to these matters or an explicit consent of one of the shareholders, mainly the investors. And for you as a founder, it's important that you clearly define these resolutions and think about what is your main goal and where do you want to have the investor have a say in and where not. One also important factor is the board composition. It's standard for an investor, usually the lead investor, to receive a seat on the board of directors. So that's why the term sheet to specify how many board seats there are, who appoints them, who has the right to appoint a board member, and something also important, do you as a founding team retain the majority control in the board or not? Important as an investor, under Swiss corporate law, shareholders without the board seat have very limited rights. That's why it's important to have a shareholders agreement in place where you have contractual rights towards the company, mainly information rights. Then we also come to the other terms. The first one, as I just said, the information right. Shareholders in Switzerland are not very well protected, mainly minority shareholders. That's why you need to have a shareholders agreement to ensure that you have contractual rights to certain information. What's common, usually a quarterly or even a monthly reporting, which is issued by the board and then distributed among all shareholders. Access to certain KPIs, financial or operational KPIs, and often also the budget for next year. So the investors can overview their investment. Without such contractual rights, they don't really have the right to such information. And then a standard clause, I put them under the other terms, but you can also put it under control terms, the transfer restrictions, the right of first refusal, the tag-along and the drag-along right. All these rights are basically here to protect the cap table, basically to protect the existing shareholders and ensure a strategic alignment among all shareholders. So it's not possible to dispose of the shares to someone that is not part of the shareholders agreement or that's not part of the initial group of investors. Then a term sheet usually covers confidentiality and exclusivity as well. Confidentiality obviously protects the deal terms from being disclosed to third parties. And the exclusivity often protects the lead investor, the investor that is negotiating with the startups, from the fact that the company is then shopping with other investors during that exclusivity phase. Usually the exclusivity phase is between 40 and 45 days. During that time, you basically negotiate the final agreements, the investment agreement, the shareholders agreement, and conduct the due diligence. The next webinar is about the due diligence, so stay tuned. And then basically the required documentation. The term sheet should also outline what agreements will be signed after the term sheet, because you remember from the timeline, the term sheet is very early. You still have to negotiate the final agreements, basically the investment agreement, the shareholders agreement. Usually you also draft the board regulations and new articles of association. Sometimes there are also other closing deliverables. For example, if you're a GmbH in Switzerland, you have to convert into an AG prior to the round or during the round. That's something that is very important. You have to disclose it in the term sheet because it often complicates the deal or the transaction, and the investor has to be aware of it. And it's also good if you're in a situation like this, you are in GmbH and you want to convert, that you talk to your lawyer before sending the term sheet to the investor, because the conversion itself in the startup space is not the easiest due to several reasons. And finally, and that's something that is quite standard in Switzerland, is the cost allocation. Many, if not all, VCs that invest into startups have a condition that the startup itself bears a certain part of the transaction costs of the VC, subject to a cap, usually 10 to 20,000, something around this. Basically, the founder should clarify when the cost coverage happens, usually only if there is a closing. And the amount has to be capped and be reasonable. That means that after the round, indirectly, the investor pays the transaction cost because his investment is not 1 million, it's only 980,000, but the money is coming out of the company after the round has been closed. As you can see, the term sheet is not just a summary, but it's a strategic document that is probably the most important document in the entire financing round because it's the basis of the final agreements. A well-negotiated term sheet speeds up the process, prevents a misalignment later, and sets the stage for a smooth investment process. So it's pretty safe to say that it's worth spending time on it and thinking about these terms we just covered today. Dominic, that's about it regarding term sheets. Do you have any questions? Or are there any questions?
Yes, thank you, Anna. Yes, there are questions that I would like you to answer. The first one that we have is, you can find term sheet templates on the internet. Why do I need a lawyer? And why can't I just fill in the template?
I mean, you can obviously use templates, but as you know, the situation in a specific company is often very specific. And if you're able to read a term sheet and also understand the consequences of certain terms, then you can try to use a template. I would advise against it. I mean, at least if you want to save cost, is to fill it out and then have it checked by someone who has experience in financing rounds. Because the problem is sometimes the devil is in the detail. So just to have a standard term sheet without really thinking about the details, for example, in the vesting, I've seen a lot of term sheets which state basically vesting, 4-year vesting, 1-year cliff. That's fine. But if the investor expects someone who leaves the company voluntarily to be a bad leaver, and you think this is a good leaver, and then you only realize once you get the final documents that for the investor, this is a very important term. You've spent a lot of money and time for something that you could have discovered early. So that's sometimes the problem. You only realize certain points at a later stage, and sometimes you also see deals being stopped and broken because they didn't have a full coverage of all important topics on the term sheet.
Mm-hmm. So, summarized in a nutshell, you can say that the templates are quite generic, but you have to pay attention to the individual circumstances and also individual expectations by the two parties, and need to reflect this also in your tailor-made term sheet. And the second question goes in the same direction. In my pre-seed round, I already had a term sheet drawn up by a lawyer. Can I use this one-to-one again? So, you know, if I take your last answer into consideration, I would suggest rather not, because in the meantime, the circumstances may have changed.
Exactly, especially if you had like the terms of a second or third round are different to a pre-seed round. You may have another lead investor that wants an additional board seat or not. You may want to shorten your vesting period because you've already worked, let's say, 2 years, and you don't want to restart the vesting period of 4 years. You may want to have certain shares not being subject to the vesting because you've already done something. And the liquidation preferences in further rounds, they also have some peculiarities, since you have to discuss with the existing investors and the future investor how the waterfall is, whether they are on the same level or whether there is there's a down round, the previous investors get additional shares, at what valuation, stuff like this. So you should not use the same term sheet for one round and another. Obviously, about 60% or 70% can probably be used, but the important stuff you have to think about individually.
So creating a term sheet is not a copy-pasting exercise,
Definitely
but
not.
needs the reflection of somebody who is experienced in that matter and the advice of that person who has seen many discussions between investors and the startups.
Correct.
Good. Then we have a third one, and it says, that's a good one. How many details of the term sheet need to be defined? For example, does the term sheet stipulate that there shall be vesting terms and details are regulated in another document? Or are all the details, like what you mentioned before, the good and the bad lever, regulated in the term sheet itself?
Obviously, it's up to the parties, but my recommendation is always stuff that you think is important to you. You should go into detail. If you think I don't really care about, let's say, drag along at the pre-seed stage, then you can, but you don't really have to go into detail. But the vesting, for example, is very important. Also, the board composition, in my view, is important, and also the list of important matters. So where does the investor really want to have a say in it? Does he want to approve every single employment agreement or just employment agreements above 150,000 salary? These are important questions to ask, because otherwise you have an operational issue. That's mainly the argument of the founders when you have to go to the investor for every single decision. That's probably my recommendation. You go into detail where it matters to you, because you can only answer that question for yourself. And you don't really have to go into detail in matters you don't really care about.
And by your experience, how long are usually the term sheets? Is it a one-pager, or is it a legal document that is 10 sides long?
That really depends. You always see if founders prepare a term sheet, then it's more one page. But if the investor has a lawyer, for example, or if the investor is experienced, you often have 2 to 3 pages term sheets. If you include the annexes, you often end up at 5 pages. But you have to see the work you do at the term sheet stage is not for nothing, because you can basically copy and paste from the term sheet into the shareholders agreement, and it makes the shareholders agreement drafting and negotiation process much more efficient if you have already agreed upon the major stuff at the term sheet stage. So it really depends.
Okay, thank you. I think that's so far all with the questions. Let me check if we have received any additional ones. No, there are no additional ones. So I would like to thank you, Alain, for your explanations, and also make an outlook to our next webinar, which will be in 2 weeks' time on the 16th of April, and that will cover the topic of the legal due diligence. So Alain, again, will explain what a legal due diligence is and what in particular, as a founder, you need to pay attention to. Correct?
I'm looking forward to that.
So do I. So looking forward to the webinar, but also to seeing you again. Alain, but also the participants today. And yes, that's all for today. So thank you very much for attending and have a good day. Bye-bye.
Bye-bye.